First and foremost, you need to understand what the nature is of that liability. What is it that the company did to incur the liability? Comes up in a number of contexts, of course, and we're going to talk about both from the direct exposure side and then some forms of, let's call it vicarious liability. But where in the corporate structure do the liabilities exist? The takeaway here is, of course, before you enter into a transaction, buyer must know which entities have the exposure, because it will bear upon not only where you're interested in investing, if that's your scope, but how you negotiate a purchase price. Environmental liability, these conferences tend to focus on personal injury exposure, but in many cases, Grace and Asarco are a couple of more recent examples. The environmental asbestos liability may be significant as well. Cleanup, remediation costs, both on a federal and state level. So it's something that has to be considered based upon, let's call it the selling company's exposure. Product liability claims, of course, extend up and down the distribution chain. So you need to be aware of any exposure to business partners, including downstream purchases of the product. We'll talk in a minute very briefly about indemnification obligations, and that could be an issue as well. And finally, insurance is not, of course, a source of liability, but it's a factor that one must consider on the flip side. If insurance is available, to whom, who are the named insureds, who are the additional names insured, for what years is their coverage? But certainly post-1985, you're going to deal with pollution exclusion provisions. So insurance is something that needs to be evaluated in any transaction, but most importantly, when we're considering asbestos companies. When we talk about products in particular, these are just some of the questions that should be asked as you're considering investing or asset purchases. Most of my client base is in banks and hedge funds and the like, but I'm also asked for our corporate clients to evaluate transactions for them from time to time, less so these days. And often there is an asbestos overhang that I'm asked to evaluate for them. And in general, these are the types of questions that we ask and go back to the seller and try to get as much information as we can to consider. What types of products? The mining cases are few and far between these days. Grace and Asarco, again, had bits of that. But mostly you're going to be dealing with companies that have manufactured some type of product. Gaskets, sealants, we all know what those are. What products, to whom were they sold? How vast was the distribution network? Are we talking internationally, nationally, regionally? All of that, of course, are factors that need to be considered to know how, bless you, Jack, how extensive the liability may be. Distribution agreements. Well, what are the contractual relationships with the distributors? What are the obligations that are owed to distributors? You would expect to see some type of indemnity. How broad is the indemnity? So as you can tell, there's a lot of work for lawyers in these types of transactions. And frankly, just like with the end users, with the distributors, who are the end users of the product? Is it to a narrow industry? Is it, we're talking about welding rods that I have some experience. Well, we're only talking about welders where the exposure is going to be limited to a certain amount, or is it something more broad where we'd be concerned about a pretty vast allegations of exposure that would lead to a higher liability? I mentioned earlier possibilities of some kind of derivative liability. So even in circumstances where the seller may not have manufactured directly any asbestos-containing products or have that kind of exposure, there may be other bases for liability that need to be considered. Indemnities is certainly one. There may be liabilities that are retained through prior transactions that the company has done. Grace, again, is an example of that over the years had entered into so many transactions that a real analysis of all of those needs to be done if you're considering, that had to be considered in evaluating any transactions. Successor liability is something that obviously needs to be considered, but yet that's one of those, you'll know it when you see it type of things. For the most part, there won't be successor liability unless they're, I'll simplify it, an insider type transaction. Raytech is a classic example of that, where the transfer of assets not only was found to be done for a fraudulent purpose, certainly was argued that the purchasing entity was a mere continuation of the prior company. So these are things that if you're an investor or interested in purchasing, you're gonna know that because you're on the inside of that transaction. The fraudulent transfer aspects, of course, are those that can come up and surprise you. I think it's fair to say that in Babcock and Grace, and that wasn't something that was anticipated at the time of the transaction. Sealed Air did not expect down the road that it was going to be asked to contribute, as it turned out, a hefty amount to Grace's reorganization. What's interesting about both cases is, leaving aside the reasonably equivalent value prong of a fraudulent transfer analysis, the interesting aspect is the solvency of the transferor at the time of the transaction. And Babcock and Grace end up in different places on that. Both courts concluded that future claims that were filed against the transferor company after the transfer date, were claims under the bankruptcy code. But from there, the courts diverged. In Babcock, the court ultimately held that hindsight was improper, and all that that the company's evaluation of the liability at the time was not unreasonable and found for the company. The Grace decision was an in limine decision, and the case ultimately was not litigated to conclusion. It was settled. But the district court there, Judge Wolin, found that hindsight could be used. The company's analysis of the liability at the time was not the relevant consideration, and that the future claim should be considered. So where does that leave us with these two cases in that context? Well, at the time you're engaged in a transaction with with a company with an asbestos liability overhang, you would better do a complete valuation based on the information available to you at the time.